In this lecture, we would like to discuss about reasonable restrictions, and particularly reasonable restrictions are associated with fundamental freedoms which are guaranteed under Article 19 of the Fundamental Rights of Part 3 of the Constitution of India. And regarding the very fundamental freedoms, already before some months we have already delivered lectures, a series of lectures on fundamental freedoms, so anyone can refer to those in our channel which were named as fundamental freedoms in part 1, part 2, part 3, part 4, part 5, part 6, like almost 10 lectures were delivered on fundamental freedoms. And now we would only like to discuss regarding those reasonable restrictions and how reasonable restrictions could be applied to restrict those fundamental freedoms, and it could only be possible by law. And law exactly means those pieces of legislations enacted by the state legislatures and by the Union Parliament, and also those ordinances issued by the governor of a state or the president of India. So, for restricting those fundamental freedoms, the very grounds which were laid down under Clause 2 and Clause 3 and Clause 4, and those were relating to the sovereignty and integrity of India, and the very ground of sovereignty and integrity of India was added by the Constitution, 16th Amendment Act of 1963. So the very territorial integrity of India is particularly refers to the very demarcation of the territory of India, and also in regards to sovereignty of India here refers to the internal and external aspects of sovereignty of the state of India or the Republic of India. And in connection to that also, we could like to discuss the second reasonable restriction, and that is relating to the right to assemble peacefully and without arms, and in that connection we could found certain provisions of certain acts, and such as such reasonable restrictions could be imposed under the Indian Penal Code and also under the Arms Act 1959 and the Seditious Meetings Act of 1911, and also Section 30 of the Police Act 1861, and also the executive magistrates have been empowered to issue orders under Section 144 of the Code of Criminal Procedure 1973 to impose restrictions on the holding of public meetings. The order under Section 144 is given when the magistrate is of the opinion that such direction is likely to prevent obstruction, annoyance, or injury to public tranquility, that it may prevent riot and affray. So, Section 129 of the Criminal Procedure Code empowers the police authorities to execute magistrates to disperse any unlawful assembly or any assembly of five or more persons. The given provision also allows the authorities to use reasonable force to disperse the assembly. The given provision is to be read with section 151 of the Indian Penal Code, which makes the non-dispersal of assembly after a lawful command to do so an offence punishable with imprisonment up to a period of 6 months, a fine or both. So, in that connection, we could discuss the decision of the Supreme Court in 2021 in the case of Rakesh Vaishnav versus Union of India, where it held that the farmers protesting against the three controversial farm bills near the Delhi highways have the right to protest, but they cannot block the roads for public usages. The court is, in the given case, reiterated that the right to protest is a fundamental right, but it has to be exercised subject to public order. The court held that there can be no impediment to the exercise of the given right as long as it is not violent and does not cause damage to the lives and properties of other citizens. And in that connection, we would like to go to another aspects of reasonable restriction, and that is relating to the security of the state. So, when it is relating to the question of security of the state, we found certain provisions relating to security of state, and that is as provided under clause 3 of article 19. So the very clause prohibits the use of right to freedom of speech and expression as to be exploited by citizens to incite violence and heinous crimes. So, in that connection, we would like to discuss certain other meanings of reasonable restriction. It aims to prohibit all such speeches or expression which, if allowed, can result in shaking the foundation of the state, overthrowing the government, waging war, or any other kind of rebellion against the government. So, in that connection, we would like to discuss that in the very leading case, that is Ramesh Thapar versus State of Madras, the order passed by the government of Madras under section 9 clause 1A of the Madras Maintenance of Public Order Act 1949 was challenged by the petitioner. The order prohibited the circulation, sale and distribution of the journal Crossroads on the grounds of maintaining public order and securing public safety. In the said journal, the petitioner used to express his opinions through weekly articles criticizing government policies. And the petitioner contended that the order infringed on his freedom of speech and expression. The Supreme Court held that Section 9 and Clause 1A of the Madras Maintenance of Public Order Act was not protected by Article 19, Clause 2, as there is a fine distinction between public order and security of the state, the latter standing on a higher footing and thereby the court held the provisions to be unconstitutional to that extent. It is pertinent to note that the words public order were also added in Article 19 clause through the Constitutional First Amendment Act of 1951. And now we would like to discuss another reasonable restriction in the name of friendly relation with foreign state, and the very ground also added under the first Constitutional Amendment Act of 1951. It is imperative to understand that as per the recognized principles of international law, the state is seen to be responsible for the acts of its citizens if such acts are detrimental to another state. As per the given principle, various modern systems of law embodied provisions that punish libel or slander against the head of a foreign state. The state, on the basis of the given ground, restrains the propaganda of any citizen to jeopardize the state's friendly relation with another state. So in India, the Official Secrets Act 1923 provides for various restrictions on the given ground. And now we would like to discuss another reasonable restriction that is provided under itself in the article under clause 4, and that is relating to public order. So also it was added under the first Constitutional Amendment Act 1951. The said ground was added after an effect of the Ramesh Thapar case. So in the case of Superintendent Central Prison versus Ram Manohar Lohia in 1960, the Constitutional Bench of the Supreme Court discussed the ambit of the phrase public order. The court held that the phrase public order has a very wide connotation. The court observed that public order is a basic need of an organized society, as it enables the citizen to peacefully pursue their normal activities of life. The court relied on the Honorable Justice Patanjali Shastri's opinion in the case of Ramesh Thapa and held that in India public disorder can be categorized under two heads. One being the aggravated forms of public disorder that can endanger the security of the state, and the second being minor kinds of breaches that are purely local significance. So, the very phrase public order can be seen as synonymous with words public peace, safety, and tranquility. The court also observed that all the grounds are further limited by the word reasonable, and also in the interest of, as it is mentioned under Article 19 Clause 2. So, beside public order, now we would like to discuss some important leading cases, and in particularly in the case of P.A. Jacob versus the Superintendent of Police Kottayam in 1993, the Kerala High Court held that freedom of speech and expression does not include the use of loudspeaker or sound amplifiers. Further, in the case of Babulal Parate versus State of Maharashtra in 1961, Section 144 of the Criminal Procedure Code 1973, was challenged before the Supreme Court to extend that in order was passed under it to restrict the freedom of speech and expression. The given provision falls under the chapter providing provisions for maintenance of public order and tranquility, whereby the provision enables the appropriate executive magistrate to pass a written order directing a person or persons to abstain from doing certain acts. So also, in another important case, that is State of Bihar versus Kamalkant Misra, as it was observed by the Supreme Court, the order passed under Section 144 of the Criminal Procedure Code can extend the life of an order passed by the magistrate beyond a period of 2 months. The court held that such an order would be an unreasonable restriction on the freedom of speech and expression. And now we would like to discuss another important aspects of reasonable restriction as itself found under Article 19 under Clause 2, 3 and 4 is relating to decency or morality. Decency can be construed as a lack of offensive restriction on the ground of decency, and morality is primarily based on striking a balance between an individual's right to express himself and the state's duty to protect morals. So, thereby the state can suppress and even punish such actions that promote indecent and offense material as provided under Section 292 to Section 294 of the Indian Penal Code, which penalize a person for selling, hiring, distributing, importing, exporting, or conveying any offense material like a book, pamphlet, paper, writing, drawing, painting, representation, song, figure, or any other object. Further, the indecent representation of women Prohibition Act of 1986 was passed by the government to prohibit and punish the circulation of any offense and indecent material relating to women. So, in that connection, we would like to discuss the leading case, Ranjit D. Udesi versus State of Maharashtra in 1965. The Supreme Court held that Section 292 of Indian Penal Code is constitutional as it is protected under Article 19, Clause 2 of the Indian Constitution. Also, we would like to discuss another important leading case, and that is Escosvo versus Kanyamal. In 2010, the Supreme Court moved away from the Heckling test and held that when literature is alleged to be offense, the specific words or pieces of the literature are not to be magnified to find the said offensity. Rather, the court should see the literature as a whole and then assess its impact on the minds of the readers. And in that connection, we would like to discuss what exactly Heckling test, the test to determine whether a specific material is offense or not. As per the given state test, it is to be seen in whose hands such material falls and whether the given material has the potential to deprive and corrupt the minds of the receiver or not. And now, in that connection of reasonable restriction, another ground of reasonable restriction is relating to contempt of court. So, the rationale behind contempt action is not to protect the judges from scrutiny by the public, rather, it is to preserve the authority of the judicial mechanism. So, in the case of Ambat versus Attorney General for Trinidad and Tobago in 1936, it was observed by the Privy Council that even judges are open to public criticism, and if a reasonable argument is put forth against any judicial act alleging such act to be against public policy or contrary to law, the court will have no power to initiate the contempt proceeding. So, in the case of M.R. Parasar versus Farooq Abdullah in 1984, the then Chief Justice Y.V. Chandra should have held that courts must be reluctant to initiate contempt proceedings. They should be initiated only in cases where it becomes necessary to uphold the rule of law. It was also held that in cases of contempt proceedings, judges also act as prosecutors to punish the person accused of contempt, and in no case should the proceedings give the impression that the judges are acting in their own defense through such proceedings. So, in particularly in the Constitution of India, Article 129 and Article 215 empower the Supreme Court and the High Courts to punish for their contempt, whereas it is the Contempt of Courts Act 1971 which defines the very powers of the High Court to punish for contempt of a subordinate court. While Section 2, subsection A of the Contempt Courts Act categorizes contempts as civil and criminal contempt, and Section 2, subsection B defines civil contempt as willful disobedience of any order of the court, while Section 2, subsection C defines criminal contempt as any kind of publication that scandalizes or lowers the authority of the court, prejudices or interferes with the judicial proceedings or administration of justice. So, in that light, we would like to discuss a leading case, E.M. Shankaran Namrudipad versus T. Narayan Nambiar. In 1970, the Supreme Court upheld the court's power to punish for contempt and held that Article 129 and Article 215 of the Constitution of India are not subject to Article 19, Clause 1 and Subclause A. And in that connection, we would like to discuss another important reasonable restriction, and that is defamation. So, the very right to freedom of speech and expression cannot be used to diminish a person's reputation or credit in the opinion of others. The act of defamation is a tort or a civil wrong as well as an offence under Section 499 of the Indian Penal Code. So, if a person is found guilty of defamation, he can be held liable for the punishment of simple imprisonment for up to a period of 2 years, under section 500 of the Indian Penal Code. So, in that connection, we would like to discuss one important leading case of 2016, and that is Subramaniam Swamy versus Union of India, where the Supreme Court held that by virtue of Article 21, every person has a right to live with dignity, which also extends protection to his reputation. It was further held that nobody has the right to neglect others. And in that connection, also, we would like to discuss another important reasonable restriction, and that is incitement to an offence. And this very incitement of offence was also added under the first Constitutional Amendment Act in 1951. The reason behind the given proposal was the word offence has a very wide meaning. It can include all the acts punishable under the Indian Penal Code and other special and local laws. And as Article 19 Clause 1 provides, so under Chapter 5th of Indian Penal Code, which provides various provisions that defines and penalizes the abatement of an offence, instigation has been provided as one of the modes through which a person can be abated. So, it is pertinent to note that Section 109 of Indian Penal Code does not differentiate between the person committing the offence and the person abating the offence, while making a person liable for the punishment of an abated offence. The restriction on the given ground were upheld in the leading case, State of Bihar versus Salabala Devi in 1952 by the Apex Court or the Supreme Court. So, in that connection, almost we have discussed all those reasonable restrictions which could be imposed by law, and exactly as law is defined under Article 12 of the Constitution. And in nutshell, we have discussed those legislative pieces or enactments, those were made by the state legislatures or by the Parliament of India, and also all kinds of ordinances issued by the governor or promulgated by the governor of a state and by the President of the Republic of India. So, almost while discussing those reasonable restrictions, as we found under Article 19, Clause 2, Clause 3, and Clause 4, in relating to freedom of speech and expression, and also regarding those freedom of assembly and also the freedom to form associations and organizations, and also those freedoms of movement and the freedom to settle and reside anywhere in India, and those freedoms to carry out any profession or occupation or trade business within India. And all these reasonable restrictions are also itself provided under Clause 2, Clause 3, and Clause 4 of Article 19 in the very name of the sovereignty and integrity of India, the security of the state, the friendly relations with foreign states, maintenance of public order and public peace and safety, decency or morality, and also in relating to those restrictions pertaining to contempt of court, and lastly those restrictions relating to defamation or incitement to an offence, and all the relevant laws enacted by the Parliament of India or the laws that we found under the Criminal Procedure Code and also the Indian Penal Code, the Arms Act, and also while discussing each reasonable restriction, we have also discussed some important landmark judgments in respect to such restrictions, either delivered by the High Courts or by the Apex Court or the Supreme Court of India.